an associate at the High Court. We also have Professor Elisa Arcioni and Professor Yane Svetiev, who will also be discussing their work at the High Court as former associates. And we'll have 15 minutes at the end for a follow-up Q&A with questions that I'm sure you all have. So without any further ado, I'd like to hand it over.
Thank you very much for that introduction. And can you see me out the back or not? I think it's very important you should be able to see me. I'm very proud to be in my old law school here. It's many years since I had my first year in law school, and I realise that many of you will be very ancient mariners who have gone a long way from your first year. Thank you for coming along today to see me. I remember working so hard to do well in my law school exams, and it only clicked for me in the last year that I should give the examiners the benefit of the little notes I prepared during the exam on the schema of my exam answer. Now, this was a very bold thing to do because nobody, I think, had ever done that before. But I thought, if I make their task easier by providing a list of the headings, and if that shows how correct and brilliant I am, then that can only redound to my advantage in my exam. Did anybody here do anything quite so bold? There's the lesson. You've all got to be bold. Bold for justice and bold for the law, and seeking always to reconcile the two. Now, we're going to have a conversation, which means that I don't fill up all of the space, even though that's a natural inclination on my part, because I've got so much to tell you about my time on the High Court and my wonderful associates, of whom two are in this room today. We're going to have a lot of conversation and then a lot of questions. But first I want to tell you something about the selection of associates, at least from my point of view. I came from a not poor but not wealthy family in Concord, New South Wales. You've heard of Concord, all these people who live in Bellevue Hill. Concord, and then I went to the North Strathfield Public School, and then Summerhill OC class, and then Ford Street High School. So I didn't have actually a disadvantaged education. In fact, I had a superb education, and it prepared me well for life in the law. In that education, I ultimately came to the Sydney Law School, and at the law school I had a number of very, very talented lecturers. But there was one who stood out, Professor Julius Stone. And you've probably heard of the Julius Stone Institute, because Julius was recognised as a really creative, innovative and unusual law professor. He was unusual because the doctrine at that time was a doctrine which was taught by Chief Justice Dixon, by other justices of the High Court, the doctrine of complete and absolute legalism. But Julius Stone taught us at this law school in its horrible building in Phillip Street, Sydney. He taught us that judges, in the performance of their work, which was the main work of evolving the common law, that judges have leeways for choice. That was his expression, though I think he borrowed it from Radbrook, a famous Austrian jurisprudence professor, and that they have leeways for choice, and particularly judges who write work in English, because, as you would know, English is a marriage of two linguistic streams, the Germanic stream of the Anglo-Saxons and the French stream, the Latin stream, of the French clerks who came over with William the Conqueror. So for every concept in our language, certainly every legal concept, is always two words: last will and testament. Will is the German word, testament is the French word. And we are blessed with a language which is wonderful for drama, theatre, but the devil of a problem for the law, because it's an ambiguous language. And so Julius taught us we have choices, and therefore the job of a judge is that of saying and explaining why a particular choice is to be preferred. And some of you may know I sometimes disagree with my colleagues on the High Court. But I was telling the LLB class, and I'll tell the JD class exactly the same thing. Generally, even when I go back to my cases, I think I was right. And it may be that that has something to do with my school education, because my school education was entirely in public schools. And my experience in the law and the research of Professor Goldring, who was Dean of Law at the University of Wollongong, is that the law is overwhelmingly populated by students who are educated in private and religious schools, whereas the law is overwhelmingly serving people who come from public schools, public school background, but also all other people. And the result of all this is that there are choices, you have to explain your choices, and I think, if I'm being truthful, my choices were influenced by my upbringing, my parental home, my background, my education in public schools, and I suppose to some extent by my sexuality and by my experience in life. And so this was the life I lived, and then ultimately I woke up and found myself on the High Court of Australia. When I was on the High Court, I had to choose two associates. I'd had two associates in the Court of Appeal as the President of the Court of Appeal. And I'd also had an associate during the decade I served in the Law Reform Commission. So I had a lot of experience in selecting associates by the time I got to the High Court of Australia. But I had formulated the idea when I was in the Court of Appeal that I should choose two associates, one of whom would be male and one of whom would be female. And that is not strictly an equal opportunity principle. You should just choose the best two. But I thought if I do this over time, it'll be fair. And also, I advertised. I think for a very long time I was the only justice who advertised. And Justice Yane once said to me, I don't know why you advertise, Kirby. Anybody who's worth being a justice of the High Court of Australia's associate will get off their backside and they'll make an application. But I knew from my search for articles when I was rejected by all the big law firms, even though I had a maximum pass in the leaving certificate at the top of the state and 2 subjects in the leaving certificate, I knew that law is a very cliquey and selective profession. And so I preferred to advertise, and I got wonderful applicants, and two of them are sitting here with me today, Elisa and Yane. Elisa was educated in law at the University of Wollongong, and that was another principle I had. Other things being equal, I would select somebody from a non-sandstone university. Sorry about that. But this was a way of correcting what I saw in daily experience, that most of the justices chose their associates from their own sort of law school, and that meant the universities of Sydney and Melbourne. But I wanted to reach out to a wider group, and I had wonderful associates, and I had a mischievous sense of pleasure when I saw how my associates were always predominant and standing out, and especially when they came from non-sandstones. Now, Yane didn't come from non-sandstone. He came from the biggest sandstone of them all, the University of Sydney. And that all went to show how I was basically trying to be fair and just in my selection of associates. And so I would advertise. I would get something like 150 applicants. I would then use my associates to reduce the number to a manageable size. I would then go through the applications, and I would choose those who I wanted to meet. And those meetings took place either in Sydney or in Melbourne or in the other cities when we went on circuit around Australia, as was the usual practice in those days. And I remember seeing Elisa, who, if I remember, had a specialty and a special experience and study, and her final year school thesis was on weeds. She was very interested in the law and the control of weeds, which is a very big issue. And so I chose Elisa, and Yane had already, at the time I chose him, been selected by Chief Justice Spiegelman to be the associate to the Chief Justice. Talk about embarrassment of riches. He had that, and I had to seek the approval of Chief Justice Spiegelman to grant Yane Svetiev. But I must confess I was very impressed that he had come to Australia without any knowledge of English. And then he went into schools, public schools, and came top of the state in the higher school certificate, and then did first class honours and medal both in economics and law. So both these two colleagues here are super bright and were wonderful associates. They came to my chambers in Canberra, which were on level 9 of the High Court building. My chambers were the best. They were at the back of the High Court, depending on how you look at it, overlooking the fountain in the front and looking up at the new Parliament House, the old Parliament House, and the big administrative building and other buildings of Canberra. And that's where we spent a year of our life. I always chose one associate. Either they came from Sydney Court of Appeal, or they were selected for 6 months or a year. And once I got through the first associate, for 6 months, because they'd been selected in Sydney, I had associates for a year, and one retired in July and one retired at the end of the end of the term. So that was the tradition. I continued my process of selection, going through them all. I had associates from the University of Tasmania, the University of Western Sydney, the University of Griffith University, and I selected them on merit, and I got terrific associates, and they worked extremely hard. They didn't actually write my opinions, though sometimes they took to going through my brilliant drafts and making very severe criticisms and suggestions which I would then take into account. So that's a sort of background. There's a new book out on associates. It's just been published. I think it's called Associates. It explains to non-court people what an associate does. In some chambers, I'm sure, associates draft the whole opinion. But in my case, they had a big role and a great benefit for me, but I had to take responsibility for the drafts. And so we're going to talk about some of those cases. And they were selected by the two associates, former associates who were before you, but it hasn't hurt them, has it? I mean, here they are, at young age, professors at the University of Sydney Law School, and doing the important and probably next to impossible job of interesting and educating the future lawyers of our nation. So thank you for having me, and now we resume a dialogue and a conversation. And I'll ask Elisa and Yane to lead off and say something about the case that they most remember, and I will make some very lucid, I hope, comments and send your way all the wiser. Do we have an hour? Or I've just done 2 hours in the LLB class, and I go to do 2 hours for the JD class, so this is a busy day. So, Elisa, over to you. You chose Yorta, which was a joint decision of Justice Gordon and myself, related to Indigenous Australians and law, and in the relatively early days, there have been some cases following Margot, but Margot had created a revolution. Yorta was a continuous revolution. Why did you choose that as the case that stood out, and what was your memory of the actual process of preparing the case?
Thank you, Michael. So I did choose Yorta because it showed to me the impact of the law and the disjunction between what judges do and the impact on people. So to give just a little bit of the background, in 1992, the High Court decided Margot No. 2. In 1993, the Parliament passed the Native Title Act. In 1994, the members of the Yorta community in Victoria commenced proceedings to seek recognition of their native title in parts of Victoria. And it didn't get to the High Court until 2002. That was the calendar year in which I worked for Uncle Kirby. At the very end of the year, the High Court handed down its judgment. As you said, it was a joint judgment of Justices Gordon and Kirby dissenting, so 5-2. And what was striking was the majority accepted the trial judge's version of facts, with the really famous phrase to say that the tide of history had washed away any real acknowledgement and living out of traditional laws and customs, which meant, in a legal sense, the High Court, by majority, denied the Yorta were an Aboriginal community that had law under their own system. The reason I remember that case so well is because from the very beginning, you and Justice Gordon were in dissent in discussions about the case, because it was a really stark choice. So in talking about leeways of choice, it was a choice between accepting that narrative of facts and saying that any break in evidence of continuation of custom meant that community was not a society that had law, or taking a different approach to recognising what does the community live and experience today in order to decide whether or not they could have native title. And it was really at the pointy end that I was very struck in the outcome, because when a judgment is handed down, the associates sit behind the judge and look out to the public gallery. In the trial or the hearing of the case, I got to hear from some of the best advocates in the country, where you had advocates for the Yane community, but then you had state and Commonwealth governments intervening together with other interveners. So this array of extraordinary advocates. And then when the judgment's handed down, you see those advocates and the public. And in the front row of the public were members of the Yane community who sat to hear the judges handing down their judgment to say the tide of history had washed away any acknowledgement of their law, and therefore they were not an Aboriginal community with law, recognised community title. So I guess it wasn't so much the drafting of the judgment, but the way in which you and Mary Gaudron demonstrated an alternative to the dominant narrative at the time, and how I just couldn't quite make sense of how the majority could say to a people before them, you are not a people with law, and watch as those individuals received how the law was going to impact upon them. Which, in the long term, I think has had an influence in why my area of research and interest is in membership and exclusion, or identity, and how the law interacts with those kinds of questions. So that's my reflection.
Actually, when I was reading because you tend to forget cases, although the law students who studied the cases return and so on, but you tend to forget them because the tide of is washed away of all cases. But as I was reading it today, you can comment if you would on this, it occurred to me that actually a very big principle in the Wick case was the principle that if the entitlement arose out of statute, you or even in the common law, you had to, in the context of native title, interpret the statute of the principle of common law in a way favourable to those who were claiming under the native title law, either common law or statute. And here the Native Title Act had just been enacted following the election of the Howard government. But in Wick, a very important principle was a source of the majority decision in Wick, and that was that it's absolutely central to the Australian legal system that if your task is to interpret a principle of law, especially a statute law, then you must do so if it is taking away the fundamental rights of people in a way that is controlling of that attempt and favourable to the people whose rights you are taking away, because otherwise it would have been made absolutely and abundantly clear that a principle of our legal system is if you're going to take away people's fundamental rights, such as their right to native title, then you can only do that in the clearest possible language. And two of us didn't think the language was the clearest possible. And I think reading it again this morning, the Yorta decision, it really occurred to me that this is not compatible with Wick. It's a bit late for me to go back and protest to my colleagues, but it is it's something that you have to consider in the light of taking away of a fundamental right. And one thing that is said in the joint judgment is if you're taking away the fundamental right, you are taking that away from the Indigenous people of Australia when the purpose of the Mabo decision and of the Native Title Act was essentially to accept the recognition of that right, and therefore it ought to be in a way that upholds the right rather than too readily gets rid of it. No legal system in the world, ladies and gentlemen, has a requirement that you've got to show that the person who is subject to it and their daddy and mummy and grandfather and everybody else have accepted the law in question as governing them. Why should the Australian First Nations people have to establish that in order to make a claim of their native title when the whole purpose of Mabo and of the Act was to recognise that it exists, and therefore that we have to adjust the claim that it doesn't exist because of the fact that it hasn't existed without any interruption, when no legal system in the world exists without any interruption. It just isn't the nature of law. So I want to rewrite the joint opinion and give it a bit more spine and a bit more light into it. Do you think that's crazy, or do you think the Wick principle could have been deployed to help in the argument in your view?
So I'll say something a bit scandalous. I think the use of legal theory, so for any of you that have done jurisprudence or any legal theory subjects, pay attention to it and then read the order judgment, the joint majority. I think they just pick and chose a couple of legal theories that were convenient to reach the outcome. Because it actually makes no sense to use some of the legal theories that were adopted by the joint majority reasoning and then to superimpose it backwards, to read in, and I think you're absolutely right, rather than adopting a principle of legality, the joint majority actually did the extreme opposite. They read in limitations to native title that don't feature in the Mabo reasoning and don't feature in the words of the Native Title Act. And in part, it's because of the submissions that were put to the court. So I guess as legal advocates, if you become practitioners, you can influence what the High Court does by actually framing your arguments. It wasn't the judges just making it up. They were relying on the way things were put to them, and one of the arguments was to actually insert a series of restrictions on the recognition of native title that don't appear anywhere in the earlier cases or in the Native Title Act itself, the statute. So lots of choices to be made as legal practitioners yourselves and as judges in the work that you're engaged in and others still engage in today.
You can see why Elisa was such a force of nature when she was working in my chambers, and she's still keeping it up, and university students at the University of Sydney Law School are fortunate to have her. And I think maybe your background at the University of Wollongong is actually a good background to bring to bear for disadvantaged people. And not everybody in Wollongong, there's a gentry in Wollongong as well as the less fortunate, but I was very grateful to have you as my associate, and I think we have. Did you enjoy that time? That's the most important.
Hugely. It was exhausting. But 2002 was an enormous year on the court. Many events occurred both on the court and off the court that had an influence on the year. One thing to mention was the last year of Justice Gaudron on the court. So I was there when there was the first female justice of the High Court, who was then replaced by Dyson Hayden. So it became an all-male court yet again. So that was fascinating to see that happening. I got to meet the Dalai Lama and many other famous people, thanks to the hospitality of Michael Kirby. hosting numerous lunches, numerous morning teas, afternoon teas, as well as doing all of the court work. So it was an absolutely fabulous year, and I got to meet Yane. And made lots of friends amongst the associates, and got to get an insight into what happens in that very rarefied atmosphere of level 9 in the High Court building, which exposed how narrow the law can be, but also how you can have an influence.
Well, Yane, it's over to you, and you, this you didn't mention, and what I know is your obsession with the case that was decided in your year at the High Court, namely this decision about competition policy. Yane is absolutely riddled with anxiety and interest in competition law, but he didn't mention two cases, Boral, the Boral case, Boral, well, they made little items that go into building, and a more interesting case of Meat Holdings, which was about Durham wheat. You've all heard of Durham wheat. Durham wheat is a particular kind of wheat product that is used to make Italian pasta. And it's a very interesting case, and I think very important, because it allowed me to repeat something I'd said unusually in joint reasons with Justice Cowan in Gerlash, that no parliament in Australia has power to delegate to a person acting under a law of a parliament in Australia that usurps the right of a person to have an unquestioned decision, because that is incompatible with the very nature of the rule of law and the answerability to them. There was a famous phrase which I quote in a passage in, at least I think it's famous, in Meat, which related to what the head of the Australian Wheat Board said to the wheat producer who asked to have an exceptional consideration of the case of the wheat growers of Durham brand of wheat, that allowed the export of that wheat, because they could export it and make a profit, whereas if they couldn't export it, they would get nothing. Their wheat would be useless and worthless. And so this affected them. This really affected them, and they had a policy of not allowing the export, but my opinion was they were obliged under our law and constitution to consider the merits of permitting an exception. I mean, there's always room for an exception. And so that was my opinion, and I thought it was pretty well argued when I reread it this morning. There's a famous passage about it, the secretary of the Wheat Board, where he was confronting this man who was just asking them to consider the special arguments that they had for exporting Durham wheat. The secretary of the Wheat Board said, "I've only got two things to say to you. First, good afternoon. Second, we are not going to allow any export of Durham wheat." I thought it was almost unanswerable that could not stand with the Constitution, the rule of law, the answerability, the right to have an exception considered by an official, and the fact that it was applicable to a private sector organisation to protect their interests, and this was something that affected relation, and always does, because it's under the statute. Now, Yane, do you think in terms of competition theory and the niceties of competition, it's all expanded this year. Do you think I was right, or do you think I was wrong? just answer. Answer yes or no.
Well, yes, I think that you were right, but I think the reason that I chose that case, and I remember it very well, is because that year, the year that Elisa and I were associates, one of the most important cases that was decided by the court was the case with not such a great name, S157 and the Commonwealth. It was a case that dealt with the attempt by the government at the time to oust the jurisdiction of the courts from reviewing cases under the Migration Act for applications for refugee status. And in that case, the unanimous court said that the Parliament cannot oust the constitutional jurisdiction of the High Court to essentially conduct a judicial review of decisions that have been taken under an act, asserting that the rule of law requires that every exercise of public power be subject to some kind of review. Now that was earlier in the year, and it actually was the last case that was handed down while I was your associate, and I worked on it. And in that case, you had a private entity, a company, which had actually previously been a government authority. But the early 2000s, we were in the height of the era of privatization of government activities, where the wheat board had become a private company that was meant to promote the interests of wheat growers who were its shareholders. And under the Act, the wheat board had been given the power to give approvals for people to export wheat out of Australia. So the power to make that decision was given to a private company. Yes, it had been a public entity before, but then it had become a private company. Interestingly enough, it was the only company that could export wheat out of Australia, so it was a monopoly. Usually, in a normal market, no company has such power, because of course they're also subject to competition, which is a disciplining force on the exercise of corporate power, where there is enough competition, which there not always is. So you had this very interesting situation where you had a monopolist who was not subject to competition, who was given a power under a statute to essentially decide the livelihood of a farmer who wanted to export wheat out of Australia. But the court, the majority of the court, found that because that was a decision of a private company, it was not subject to judicial review, which essentially meant that it was not subject to any kind of review, and in fact it was not subject to any kind of discipline, because usually in a market you have competition discipline, in public entities you have administrative discipline, and here there was not. So that's, I think, was an interesting case for me, because when the courts were discussing and concerned about their own power, they protected it in the privative clause decision, but not so much in the domestic law. So it was a very memorable case, and both cases that I nominated, they did involve competition, and in a way it was partly because I had always thought that I would do graduate work in economics, and because that's what I had done before my law degree, and I was a lecturer at the School of Economics at the time while I was finishing my law degree, and it was really the year on the court that made me decide to continue down the path of the law. So it was a very transformative year for my own future career, though many of my colleagues still think that I don't really do law, but we'll leave that discussion for another time. That's all by way of the reflection.
Both of you have been very discreet in not mentioning one feature of the year 2002, and that was that it was during 2002 that Senator Heffernan attacked me in the Parliament, in the Senate, and using documents which were quickly established as false, and resulting in an apology on the floor of the Senate. But that was a terrible time to go through. Terrible for me, terrible for my partner, terrible for my father, terrible for my family, terrible for people who supported a liberal view of law, and terrible for my associates. So that's a feature of public life that you can never necessarily get away from really nasty occasions, which, at least in my case, go over within a week. But do you remember that time, Yane and Elisa?
I'm going to read what Michael wrote in my copy of the High Court of Australia Oxford Companion at the end of that year. Dear Elisa, I won't read it all. The year 2002 had its dark side, in the court and in the world. The events of March 12th will be written on our hearts, like Section 92 of the Constitution was written on the heart of Chief Justice Latham. But like the old jurisprudence of Section 92, these events and all else pass away. I won't read the other parts because that was about me, so I won't read that part. Can I say the extraordinary thing about Michael on that morning was that I walked into chambers earlier than usual. Michael was there, as usual, before me. The phones were going, the email was just flooding in, there were fax machines, faxes were coming through. Something strange was happening, so I walked into your room and asked what was going on, and you said, "It's okay, it will be all right, let's get on with work." And so what followed was disgusting media attention, awful things happening, and yet Michael focused on work, was concerned that we were okay in the circumstances of intense public scrutiny, and of the thousands of emails and phone calls and faxes came in, all but a tiny handful were messages of support. And when eventually Mary Gaudron rallied people to go and investigate what had happened, the truth came to light. And allegations made under the cover of parliamentary privilege were proved to be false. And throughout it all, Michael just kept working.
The Commonwealth driver who made the allegations at the behest of Senator Heffernan later committed suicide on the Christmas party of his family in the shed at the back of their home. And this was an illustration of the fact that people can do very cruel things to each other and act on wrong evidence. And this is something we lawyers have got to face up to. These are the problems that we are confronted with. We had a big case in the High Court that day, which was about the entitlement in the law of negligence for oysters in the Brisbane waters, which had been contaminated by effluent. And so I spent the whole day and the next day listening to that case about the Brisbane waters, oyster farmers and their claim for damages. But there's something wonderful about the law. You can keep your feet on the ground, remember that there are other people with problems, and as it happened, it all blew away, but it might not have done if there had not been an opening up of the falsity of the events. So that's a little backstory of life on the High Court during the time of associate. Happily, that is a rather rare event, but it was really a very nasty experience, including for the associates. However, we got through it. And do you look back with happiness, Yane, on your time on the board?
Well, I often say, only half jokingly, that that was the highlight of my career, and it's been downhill from there. Jokes aside, I think that one of the messages that we would like to send with this conversation is that having an experience in associate, not only at the High Court but also at any other court, is very important, and it kind of gives you a perspective on the way that the law is created that's quite different, and it maybe even punctures some of the idealized notions about courts and judges that you might have acquired in the years at the law school. And I guess if you're under any misapprehension that the only job you can end up in with an associateship is to become a law professor, please don't. A few weeks ago we had Andrew Lee, the Assistant Minister for Competition here at the law school, so he is in politics. And of course Samantha Boston, the current Governor General of Australia, both of them are former associates of Michael Kirby. This being an associate can take you in very many different directions. And something definitely that you should consider as you go through law school.
And you should remember, I said it to the LLB class this morning, and I'll say it again to the JD class, you've got to be in it to win it. If you're thinking that you might become a High Court Justice, or if you're thinking that you might become a High Court Associate, you're not going to get there if you don't apply, if you don't stand up. And particularly, to be an associate, you've got to put your name in the ring. And the University of Sydney have got a very good record in having people selected. And for those jobs, and there will always be justices of the court who want to equalise the playing field and make sure that I have very good associates from Bond Law School and from the University of Queensland and other law schools, and you've got to be in it to win it. So at the time when you are considering what your future is, appointment as an associate doesn't have to be the High Court. The Court of Appeal or the Supreme Court or Federal Court, it's a very important learning experience. And you will, as Justice Hope, my wonderful colleague and friend on the Court of Appeal of New South Wales, said at the end of his service to a farewell ceremony in the great Banco Court in Sydney, my associate said to me, just before this ceremony, I came here thinking that I was going to have a lot of people who were the same as the ancient Greek philosophers, contesting the great and mighty questions of the time. And instead, I just found a lot of old men who were concerned about justice for other people. And that's not a bad thing to be proud of. Justice for other people, according to law, the principles of justice and leeway for choice. That's what I learned in this law school. That's what you should learn for your life. I think we've now reached the closing time, and therefore we should have a big round of applause for Elisa. Photos will be taken.